Is a lighter day. So we're supposed to do 2 lectures. One is done. One more I'll talk about continue on licensing. And then we'll have lunch break. And then we'll spend some time on your assignment. Very similar to what we were doing yesterday. We'll keep the same approach. And so what's the time now? It's 11:45. Should be done with this 12:30s. We can try to aim for 12:30, lunch 1:30, and then if we spend 1.5 to 2 hours, 3:30. So it should be done by 3:30, so you can have more time in the evening to do what you like to do. I'll go on continuing my Chandigarh exploration. I'm loving it, it's beautiful. Just to be in the same city after a long time. So I'll do that, but so it will be a shorter day for you, for all of you. 3:30. We should finish definitely by 3:30, if not before. Okay. All right. Wanted to do something different, but maybe I'll do it tomorrow. So a question. Somebody asked me a question during break time about PCT. And rather than answering this person, I thought I'll talk to everyone. So let me explain the patent process. You might find this term PCT a number of places, and that might confuse you. So we normally start with the first application has always to be done in your country where you have done the innovation. So I'm in Australia, so I filed in Australia. If you are in India, you will file to Indian Patent Office. So the first application is called provisional patent. This is in country that you reside. Now this provisional application is not a patent, it's an application. And Patent Office does not review this application. They just take it and save it. What it does, it creates a date of filing. So in the patent business, okay, I think you need to go a step back. In patent business, the date of going to Patent Office is critical. Any innovation that we are trying to do, let's say we are doing it here, somebody in Australia, China, Russia may be doing the same thing. All right? Now, how do you decide who gets the right to that invention? So master's project, PhD project, you might be working on it here. Somebody in New Zealand pharmacy school may be doing the same thing. A lot of the times those things are not known. They don't publish, they don't talk on LinkedIn. You don't get to know what else is happening in other places, right? So the only way to put your stamp on it that this is my invention is to file a patent or publish. Now if you publish, you can say this was my work, I have published it. That's the end of the story. That invention will never reach anywhere, which is very unfortunate part. I still don't know how to deal with that problem. I deal with PhD students and masters, and this is a constant issue for us. My students want to publish. I have to stop them from publishing if they want to file a patent. I have a colleague in my lab. Her name is Shudong. She's a chemist, medicinal chemist. Her principle is she doesn't allow students to attend any conference, doesn't allow any publication till they finish PhD. And recently I was looking for a staff for my lab. I got an application for one of her students. Application said, this is my CV, I've done PhD, this is my project, 0 publication, 0 conference. I couldn't do it because my boss was waiting for patent filing. I simply deleted that, I answered politely and deleted that mail. I would never hire that person. Somebody who has never written a paper is of no use to me. So, and the same thing will happen to this person when they go to different places, right? Employer will struggle to give them a job because they don't have the right thing. So that's a big challenge. Now, if we allow them to publish or present in a conference, we cannot get a patent. So that's a dilemma which all of us academics deal with all the time, and there's no simple solution. So going back to this discussion, so your first patent you filed in your country, which is called provisional application, which is a very simple application. It's not reviewed. Patent Office will not do any search on it. They will just save it, but it's made public. So our levodopa carbidopa patent is online, Australian Patent Office, provisional patent. Everybody in the world knows that Sanjay and Deepa have their right on this invention. Not the right, they have filed this application. The patent is not yet granted, so it's not a right. Are you with me? Please stop me if you think I'm going too fast or something is not making sense. Sir, this gentleman in glasses. This person. Tell us, what are you watching on your phone?
I think they are.
No. This is just a sec. Share with us what are you watching. What is so important that you are concentrating on your phone? Yeah? Lab? What are you watching? लैब का काम है, आप बाहर जाके कर लो प्लीज. Sorry. Okay, so this provisional, so in our case what has happened, we have filed a provisional patent. There's a patent filed, not granted, and it's available on internet. You can search for it. Anybody in the world can search for it. The patent says levodopa carbidopa injection, UniSA, Sanjay Deepa, and XYZ are the inventors. This is the invention. That's the first step. Now, once this provisional is filed, we get 12 months to go to the next step, in which we can collect more data and we can add information. At the end of 12 months, I have two options. I can file a patent in Australia, which will be a final application. This is provisional. This time we are telling patent office that we are submitting this invention request. You don't need to search for it, you don't need to review it. And that's why it's very cheap. I told you it's about 4,000 Australian dollar, 4 to 6. Second is final application, which would be almost 20K for us. And this application would mean now we are telling patent office that our application is submitted, you can start reviewing it. The other option is I can go to what we call as PCT. This is another international body, it's not Australian body, it's called Patent Cooperation Treaty. So it's a treaty between different countries which sets the date for date stamp. So if we file PCT, that's again similar to provisional patent, but this is now international, not country specific. So you submit to PCT, it sets my date on all the countries covered by PCT, which is a long list of countries. With PCT, we get 18 months, and then we submit final application in each country. So once I file in PCT, then if we put some date, let's say we file this on 1st of Jan 25, provisional. That gives me 1 year to file the final, which is 1st Jan 26. If I do this PCT, that gives me another 18 months, which will take me to 1st July 28 to submit the final application. So I get more time. In this process, we keep on collecting data, add more information, file the final application. But once we go to this stage, we have to decide which countries we want to file patent. We'll have to do in each country separately. But all of these, in the meantime, what's the significance of this date? In this time, if any company, any other country, anybody else wants to come to PCT or filing, they would look at this application and say, these guys have rights on it because they came to us first. So the date is critical in terms of patent business. All right? So final application has to be still in different countries. Okay, questions? You have something? Go ahead. Good question. PCT, I'm saying international, but PCT is not a patent. It's an application. PCT will not review your application. They will not grant anything. There's nothing like PCT patent number. You get number only when you file here or in each country. It's basically a mechanism to protect your right. Anybody who came after 1st Jan 25, they will be denied that application and we'll get priority over them. So this is not reviewed, this is not reviewed. This is just the stamping that वो था ना बस में सीट पे रुमाल रखने वाला है कि अब ये सीट मेरी होगी आप बैठूंगा तो बाद में आके वैसा वाला है कि सीट पे रख दिया कि अब मेरा डेट लगा दी अपनी कोई और किसी और को नहीं मिलेगा पर ये जरूरी नहीं कि आपको ही मिलेगा because the review process will still happen. Any country you go to, say you go to USA, US will review all the information that you have submitted before this date. Whatever was, when you submitted the application, what was known, did somebody already had that innovation identified? And if they find something, they will reject your application, send it back. Does this PCT make sense now? It's very confusing, but it takes time to get to it. But the simple terms is the date stamp. That's all you get with it. So PCT is not an authority. PCT is international body, and that goes back to the same question, why can't we have global patent? There is no global patent. PCT is only giving you a date on which you're setting your priority date, that you have the right to it. So the beauty of this, all of this is, after this date, let's say in March 25, somebody in China went to Chinese patent office, they want to file a patent on it, they won't get, their application will be rejected straight away because this is available online already. So we are stopping everybody else in the world to be making a case for it, basically. We may never get it here, but for 28 to 18 plus 12 months, 30 months, we have stopped everybody else from filing a patent. And if we don't go to this stage, all of this is prior art, which is already available in public domain. So nobody else in the world will ever get a patent on it, because this is already known. It's available internationally. So we basically kill the innovation. We can decide, it can very well happen in our case. We may never get to this stage. We are only here up to this stage. We are not even gone to PCT. So if we decide not to go here, this invention will be killed forever. There will never be a levodopa-carbidopa patent in the world. We can take it or nobody else will do it now. It's a very funny business. It's a bad business actually. But that's how you protect invention. There's no other mechanism. Because if you don't have that, a company would never show interest in what we are doing. And if company doesn't show interest, the product will never become available to people. So it's not just the money factor, it's also, there's a need for this product. We cannot commercialize it. We don't have that, it's not our mandate. Universities are not designed to manufacture and sell. So we'll never do it. And if you don't do it, if you don't complete this process, the injection will never be available to public, to patients. Okay, are you following the cycle? Make sense? Yes? Okay, good. Any other question on what we have covered so far? We have time today. I don't have to rush through it. I really want to take it easy, and I'm trying to make it as simple. This is very complex. It takes years to understand what I'm talking here. So I'm trying to simplify it as much as I can. File patent? No. Climate zones do not matter. Each country has only one patent office. They are not state-based. You know, in India, there's nothing like Chandigarh patent and Punjab patent. There's only Indian patent. So you file only one application. It's the same in every country. US has only US patent. There's nothing like New York patent or New Jersey patent. There's no difference there. Australia is only one as well. So it's a federal level, central level thing, not state level thing. Or if it became state level, it would be a nightmare to manage. You don't want that to happen. Okay, anyone else? No? Okay, good. Let's move on with this topic today. We need to complete this bit. So what we are going to cover in this process is continuation of our first session. Tech transfer agreement fundamentals, structuring principles, key clauses on deep dive, and real world insights. So tech transfer agreement. So once we are, in our case, our business office, once they talk to a company or a donor or anyone who wants to work with us on developing a product, we start negotiating the terms of contract, licensing percentages that we were talking in the previous lecture. Then it has to be formalized in the form of a document, which we call as tech transfer document, contract. And that's what we are going to talk in this session. It's more than a simple contract. It's a legal document that governs transfer of into IP related know-how from one party to another, defines right, responsibilities, financial terms for both parties. Clarity, some of the key things which are required for any kind of contract. Clarity, fairness, flexibility, enforceability. So clarity is avoiding ambiguity. You try to define as clearly as possible. Fairness, it should be mutually beneficial. Most of the time, as I said, in pharma, it's a collaboration model because we don't have a product to sell. A company is not buying a product which they can market tomorrow. It still has to go through development phase. So it's a collaboration type thing where we have to have trust on each other, we have to have mutual relationship which benefits both. If it benefits one party, it will fall apart. It will not work. So it has to be mutually beneficial. And balance to ensure long-term success. You want it to succeed. You're not doing all this to fail after 2 years. Because then again, you're back to square one. In most cases, your innovation can be damaged completely if you license to the wrong person, wrong party. So you want to do it right to keep it going. Flexibility, it should accommodate uncertainties of commercialization, market changes. Enforceability, the clauses must be legally sound, enforceable in a court of law. Flexibility is extremely important because there has to be an exit clause as well. For example, let's say a levodopa carbidopa injection. Pfizer decides to take it from us. We sign a contract, we start doing it, and we create milestone payment, phase 1, phase 2, phase 3, this is what we'll get. Let's say, levodopa, carbidopa are currently established drugs, very commonly used. Let's say 3 years down the line, somebody finds some side effects with levodopa. That can happen. It's out of my control, it's Pfizer's control. Nobody can control it. It happens all the time. Drugs have been withdrawn by FDA from approval list. Celecoxib, you remember the story? It was successful many years and then it was pulled back. I don't know if it's available in India, but most countries they banned Celecoxib. You can't buy it there. So it happens all the time. So if that happened, what's the point of having this agreement with Pfizer? Why would Pfizer continue investing into it? Okay? So you have to have the flexibility, so that has to be written in the contract that for some commercial geopolitical reasons, if we have to change or cancel the contract, we should be able to cancel it. And that applies to both parties, to them as well as to us. There may be something for us where Pfizer may become bankrupt. Okay? Then I don't want to lose my invention. I should have the flexibility of going to some other company. So flexibility is useful both ways. And they have to be equally shared. Okay. So what is involved in tech transfer agreement? Preamble and recitals, definitions, grant of license, core clause, what is being licensed and for what purpose, financial term, how will they be paid, due diligence and development obligations, representation, warranties, legal promises, terms and conditions, dispute resolution, how will disagreement be handled. In any kind of contract, they say you should always have a provision of what if. Okay? What if things don't work out? Then what are we going to do? Same thing applies to marriages, divorces, The same, if you don't have a contract, you get caught into it. So miscellaneous confidentiality and some of that. So let's look at it. Preamble and recital identifies the parties, who are the two parties involved, or more than two. This is an example of how it is written. Exclusive license agreement is made, entered as of this date between this and this. License is the sole owner of IP defined herein, desires to obtain a license to said intellectuality. So this is exact language what we'll use in first paragraph of our tech transfer contract. All you need to do is fill the names. You can use the same language. It comes from lawyers actually. And you can see it's starting to sound like legal language. Right? That's what you need to have in the contract, because this document can go to court. If there is any disagreement, then you go to court to fight it out. That's where this becomes useful. Definitions, whatever is covered, you try to define those. Grant of license, the core clause, that becomes critical. What are you covering with this? What is the scope? What is license? Patent rights, copyrights, know-how, field of use, for what purpose, territory. If you want to control that, we are not giving you, you need to specify whether you're giving rights for India, China, or all over the world, or specific countries. That you have to indicate here. Exclusivity type of contract, 3 types that we discussed earlier. Again, the language is licensor hereby grants license, exclusive worldwide license. So this means we are not controlling which territory. We are saying available to anyone, everywhere. Okay. Financial terms, show me the money. That's a nice title. So this is about money, upfront fee, running royalty, milestone payments, minimum royalties. So these are some examples how this can be written. Licensee shall pay one-time non-refundable upfront fee of $100,000. Shall pay license, running royalty of 5% of net sales of licensed product. Right? Milestone payments. Can you see the difference in these 3 terms? Are you able to interpret the difference? In the first case, we are saying you have to pay us $100,000 to do anything further. In this case, you are not paying us anything now. We develop it together, but you'll pay us 5% of net sale when the product goes to the market. So the company in this case is not taking any risk. Okay. Third case is milestone payment, $500,000 upon FDA approval of the first licensed product. I'm currently working with a company, very interesting contract they came up with. I can't name them because of confidentiality. We are developing 4 formulations for them. This is a veterinary product, multinational company, top 3 in the world. We have 4 formulations which we are trying to develop. Very difficult project, challenging. That's why they have come to us. Now, we worked out a cost. This is what we'll take. I've hired a staff who is working on that project, her salary and other cost, and we said this is the money. We asked the company, will you allow us to publish? And they said, no, we won't let you publish anything. So if the company doesn't let us publish anything, then we have to have a reason to work on the project. Why am I wasting my time on it? I'll make the product, give it to you, you'll start selling. What have I done in this process? So we told them we are going to charge you a premium. If my cost is 100, I'm going to charge you 120, 130, whatever I can negotiate with. This company was very smart. So this extra money that I was asking, they said we are going to divide it into 2 parts. One part which will agree to you because you're doing this project for us anyway. The second part is subject to each of these 4 formulations getting registered. So you develop it, we scale it up, then we register with the regulatory body. If they accept the formula, if we get to a point where we are able to market it, we are going to give you this much money, which is about 20% of the total contract value. So if my contract is $100,000, they will give me $100,000 now to work on the project, but for each product which is registered, I'm going to get 20,000 more. We thought which was very innovative, but then we thought if we are working on the project, they have to take the risk, we have to share the risk. The risk here is I can be unsuccessful in developing a product. Those 4 products are very challenging, and chances are we won't be able to get all 4. We might be able to get 1, 2 or 3 of those, or even 4, who knows. If you are able to get 2, the company is able to register to, they will give us $20,000. Small amount for them. So that's how they've created that contract. So there's a lot of creativity which goes into it. You write it up in a way that benefits you. So that's a negotiation thing that, and I have to agree to it. So it's written in the formal contract. So the language of that contract would be, licenses should pay an upfront fee of $100,000. For each successful product registration, they'll be paying additional $20,000. Simple. That's what we have in our contract. Due diligence, the development obligations, keeping the licensee accountable. This is licensee agrees to use commercially reasonable effort to develop commercialized licensed product. Licensor with a written progress report on semi-annual basis. Now you want to create some reporting mechanism. You don't want to give it to Pfizer and then Pfizer sleeps on it forever and nothing happens. Because if they did, then I've lost my innovation. It's not reaching anywhere. So you create some mechanism of weekly meetings, monthly meetings, reports. Somehow you try to bind them that you'll be progressing. And then if you're not progressing, a termination clause. In my case, if Pfizer is not performing, I should be able to give it to somebody else. So you want to have that in place. Representation warranties, that's a sort of committing that what you have done is the right thing. So you want to indemnify each other. Who pays when things go wrong? Now, in this case, Pfizer is taking this license from us based on relying on our data. My PhD students may have faked it, right? They have no mechanism to check it. They're relying on what I'm presenting to them. So if Pfizer takes our formulation, starts doing release study the same way as we have done, and they don't get the same data, they have lost all their thing, and we should be covering that cost. Or vice versa. They can do something wrong which we need to be covering. So that's also part of licensing agreement. Terms and condition, this should have beginning and end, termination of clause, beginning, length of the agreement. Normally you would want to bind with a license, with a thing, that continue expiration, last to expire patent. So because if you don't have a binding clause, Pfizer can take forever and they may not do anything. So you want to say, in 2 years' time we want this to happen, otherwise we'll terminate. 3 years' time, 5 years' time, this is what we want to happen. So it keeps parties committed to what they're supposed to be doing. Dispute resolution, negotiation, mediation, arbitration, governing law. One of the most difficult things that I have experienced in international relations is this statement here, governing law. So I'll give you an example. Let's say we start working with Indoji here, and we want to buy one of our cosmetic technology. Indoji, you're not listening. So let's say they have developed something which we want to license from them. I'm in Australia, I'm an Australian citizen. She's in India, Indian citizen. We come to an agreement. We create a contract. Now and we have to have what if clause, what if things don't work out, termination, if you want to break the contract. Most of the time, termination can happen in 2 ways. One, by mutual understanding, it's not working out, let's separate or break this deal. The second is, if she says, I've done what I was supposed to do, I would argue we are supposed to do. To terminate, I might have to go to the court. We might have to go to the court. Now, which court we should be going to? She doesn't want to come to Australia. I don't want to deal with Indian regulations. And there's no international court. There is an international court, but that is useless. It deals with bigger problems like Russia-Ukraine fighting. It deals with those kind of things. They don't deal with smaller issues. They are too small for them. Okay? So in this case, governing law is the most fighting thing, companies and international. It won't happen. If Induji talks to somebody in India, this issue will not come up. It will go to Indian court. She can say Chandigarh court, somebody can say Madras court, that can happen, but all within India. But internationally, it becomes a nightmare to sign that contract because, especially Americans, I do a lot of work with Americans, they don't want to come out of US, they want to fight in US for everything. because it's easier for them and they know the system. For us, if I want to fight in US, I have to find a lawyer in America who fights for us. So this is one of the difficult ones that I've experienced many times with any kind of international contract.
You have to select a middle country somewhere.
Sometimes they select a middle country, sometimes they select a third country, which becomes even more non-relevant. It's of no relevance to any country at all. But then that may be the solution. That's again negotiated. Who needs it more? Who is willing to give up? Kind of thing.
Let's hope you never have to face that.
Yeah, I know.
I always, when I sign, I just think inside myself that, okay, this should
It's
not
not
happen.
coming. It's not coming, yeah. But they do come. It happens.
Yeah.
Okay, now again, similar to other thing, I have some examples. Pharma market. This is an example of a success story. Antibody or autoimmune response. Agreement structure. Colombia licensed antibody tech to Abbott. Milestone payments. High success. This particular product became a 9 billion product. Colombia earned hundreds of millions in royalties, which is coming out of a university, and that's a significance. A failure story, gene licensing technology that was done by a university in Taiwan. An antibacterial gene derived from a plant species developed by Academia Sinica's research team. Licensed with a Taiwanese biotech company that lacked adequate due diligence, and they just couldn't deliver on it. So finally it failed. So again, I have heaps of these examples in AI, digital health, food and agri-tech, PepsiCo's contract farming of potatoes in India. That's a big success story. PepsiCo, they're supporting 25,000 farmers in India to produce this particular kind of potato. Unsuccessful, super cabbage, which didn't work out. इसलिए नहीं चली ना. Green energy. So I'll skip these. Space, unsuccessful in space. These success and failure stories are in every field. You just need to look for them. There are hundreds of those out there. I picked up some examples. I've tried to structure 6 different areas in all my lectures and give you examples from each to understand and appreciate. And they are of common interest. Space is common interest, AI is common interest. So try doing that. I can spend hours on it and talk about each of those in detail, but that's not the point. Okay, so what we have seen is successful, unsuccessful tech transfer cases. Designing it properly is right. You need to do it right when you're setting up the contract. Now we'll create a hypothetical tech transfer agreement. Medical device license. So this is a hypothetical case which can be similar to, you can use these slides in your assignment, right? Same thing. Patented surgical tool from a university lab, University of Innovation, MedTech, all these are fake, not real. So you create exclusive worldwide license to the patent. Financials, 50 upfront, milestone, FDA clearance, due diligence, must submit a commercialization plan within 6 months, and indemnity, fully liable for product liability. Okay? So you can literally cut and paste these and put in your assignment. That's how you can design it. What is the step-by-step process? You'll write a preamble, identifies the university and medtech, definitions, grant of license, there's a language given here, financial terms, due diligence, indemnifications, terms and termination. Importance of legal counsel, this is legal. Legal in the sense that if things go wrong, you might have to go to the court. And the language has to be, so you have to involve a lawyer in this process. Not for your assignment, we are not providing you with lawyer here, you don't need that, but most cases, our university has lawyers. And every time we sign a contract, our documents are sent to lawyers. They look at it, and once they approve, then only our business office can sign the deal. Otherwise, they can't. So universities make it mandatory for lawyers to look at it, accuracy of it. Okay, key takeaways. Strategic structuring, focus on core clauses, embrace adaptability, legal expertise, that's important. Generally, companies want to keep it as flexible as they can. They want to keep it very broad, very open. They want to include as many, and they want it to their benefit. So they would want to give you minimum possible money and get the maximum out of you, and you have to fight for every dollar. This is like negotiation. When you are buying or selling anything, you want to do the same thing. So it's the same thing. It's done here. As part of this process, you need to seek specialized counsel, which is the lawyer, conduct IP audits regularly, develop clear internal policies, stay informed on the best practices. Some references here, and these are references for case studies which are listed here. If you want to see more details, you can look through those. They are vital catalysts. You can't go to the next step unless you have done this step. So in your innovation journey, you can develop something, but unless you get to this stage, you won't be able to proceed, you won't go very far. I know you can develop something in the lab, unless you file a patent, unless you find this kind of commercial agreement, it will not reach anywhere. Unfortunately, that's the reality. Okay, so that's all I had to cover. I'm happy to discuss. Now, if you want to talk with reference to your assignment, we can go through that. Anyone has anything to talk about? This was a relatively simple thing, but happy to discuss.
सर एक्चुअली मुझे पूछना था हेलो सर अबाउट द लॉन्ग एक्ट पीडी tomorrow yesterday you discuss about the long term PD of your product that levodopa one so what you pitch for the company, what is the main thing you keep in your mind and what they suggest response or any feedback to you, anything they said to you to improve or anything else, how you pitch to that company?
Okay, again, I'm not sure if I got the question right, but I'll try to understand and explain back. And you can tell me if I didn't answer it. So the question is, what feedback do you get from how do you make your innovation appealing to companies, right? Different language. Right? Why would a company come to you? Or why would they talk to you? Okay, where do I start? A company would talk to you, a company won't come to you for charity, that's given. They will come to you only on things on which they can make money. Okay? So industry will find you and your innovation. Finding the right company is a big task. It takes a lot of efforts, a lot of energy. In my team, I'm experimenting at this stage. I've hired a business development manager within my own team. I'm paying full salary of a person. His job is to make me famous. So if you are following me on LinkedIn, you might be seeing a lot of new posts every week. I'm paying someone to do it for me. Okay? The reason is those ads make us famous. Somebody searches, anybody in Australia searches for pharma development research, enters on Google, they will find us because of my LinkedIn post. And then they will come to us. This levodopa carbidopa story, we made a lot of noise about it. He has been posting on LinkedIn every third or fourth day. You can't be doing too much of it, so I have to stop him. Stop. But if today you're sitting here, you can try doing Google, enter Parkinson's long-acting injection, you probably will find us. At least in Australia, you'll find us, may not happen in India. Because Google also tends to be regional specific. We have not advertised in India. So it's a challenging task. Companies look for what is useful to them. They are very, very critical. They won't simply take anything from you. And they would take only those things which they can market one day. Again, if you are working for a company, what would you do? If you are the business development manager for Pfizer, and they tell you go out and seek new excitements happening in the world, what would be your approach? What are you going to check? Think from that angle and you get answer to your question. Put yourself in that position. Your job is business development manager for Pfizer. You will look for products where there is less risk, enough innovation, IP covered, scale-up possibility, real market need. Somebody should buy Pfizer's product when they buy it, do it. And they will ask those questions. If you don't have answers to those, they will simply say, thank you, bye-bye, see you. It again happens a lot with us. We see a lot of companies coming to us, they listen and they go back and say, no, we are not interested in it. It has to fit in their model, financial model more than anything else. Anyone, anything? A new thing which I have noticed, I'm not sure, Indoji, you might help me with this. I'm not sure if it is happening in India. Something that I've seen happening in Australia, it's happening quite a lot. Companies are coming to universities and they are saying, we'll give you a small grant of up to $50,000, pitch your idea to us, and give us only information which is not confidential. So people like me, we are hungry for money. We need money to cross our valley of death. We put together our idea and we go to them. Now, company might offer 3-4 of those over a year. Let's say $200,000 spent. But what do they get in this process? They get proposals from every possible university in the country. And they've already written the clause that give us non-confidential information. So they pick up that ideas and they start working on those by themselves. We don't have any rights to even stop them. They're playing a very smart game. So it started 3-4 years ago. When that happened, I used to submit those applications. Now I don't. I've stopped doing it because I'm giving my secrets for free. If I tell someone long-acting injections, Parkinson, how difficult it is for somebody in company sitting that there's a potential for this idea. Somebody has done the groundwork. Let's start working on it. I may not tell them the name of the drug, but there are 5 drugs which are used in Parkinson's. How difficult it is to pick that one up. Right? So companies play those kind of smart games as well. Does it happen in India? Do you have seen that?
Not very common yet, but yes, they are coming to us.
They're coming.
And not like, as you say, sometimes you get mails and where they want to discuss those sort of things are also happening now.
Yeah.
And that is very common. They sign a CTA with you, they want to discuss your technology. They take the discussion to certain level, 6 months, 8 months, saal, and then they suddenly drop.
They stop. Most cases they would either decide not to do it or they'll start doing it by themselves.
Yeah. So they tweak it, and some of the times I came to know that they have a product.
Oh, good that you reminded me. Something that I didn't mention, I should have in my notes somewhere. Confidentiality agreement, we didn't talk about it. Before we start talking to any company, I mean, we moved quite ahead, filing patent and licensing. But the first step, which I should have mentioned, is CDA, Confidentiality Disclosure Agreement. That's a document which is signed between the parties when we start talking to them. On good faith that we'll keep each other's information confidential. Okay? So this is a document, it's not a contract. There's no money involved. There's no discussion of money. When a company approaches me, first thing I say is, let's sign a CDA. CDA is a 2-page document from our business office. They will send it to them or they will send it to us. They will agree, negotiate, and they will say, sign, done. The CDA document is simply saying that what we are talking to you, you cannot misuse it tomorrow. But again, if they misuse it, I have to go and fight with them in the court. There's no other mechanism. And universities don't have that power. They probably know that. So people sign CDA quite happily. Imagine somebody in Punjab University like Indoji, somebody takes her technology, signs a CDA, go home and start doing it. I don't think she or Punjab University would have financial power to deal with them in the court.
Never.
You would not be able to do it. But but in other countries it's a lot more serious. So our university takes it very seriously. So CDA is filed in very first step when you start talking to a company. Before I talk to a company, I always sign CDA. Sometimes if they are coming to me with their problem, I don't care about CDA, it's their problem. So they are coming to solve their thing. They are interested in signing CDA with us because they are going to tell me their problem and I can misuse it. I can have a master student, PhD student working on it. So to avoid that, they will have CDA. They will insist on, Sanjay, we want to work with you, but before we can tell you what we want you to solve, let's sign a CDA. So that's the first thing which is done. It's a universal practice. It's done everywhere in the world. Okay. Any question anyone has? This side is very quiet. Are you feeling lost? Or you are with me? Yeah? What do you think? Has it been too difficult? No? Okay. All right. So if you don't have any question, we are exactly at 12:30. It's perfect time for break. I'm good in keeping time, right? See, 12:30 means 12:30. Okay, let's break for lunch. We are coming back at 1:30 and then we start with tutorial. Thank you.